Let's be honest. The rules for police encounters have always been confusing. But for gun owners, they can be a minefield. One wrong move, one wrong word, and a simple traffic stop can spiral into a nightmare. What I'm about to share are 10 fundamental principles, rooted in decades of constitutional law, that can protect you, your freedom, and your family. And the number one principle we'll cover today is so misunderstood that it's been used to justify violating gun owners' rights for over 50 years. If you're carrying and don't know these rules, you're rolling the dice. So, stick with me, because what you're about to learn could be the most important self-defense tool you ever have. Quick disclaimer. Look, I'm passionate about this stuff, but I'm not your lawyer. This is for educational purposes only. Laws change and vary from state to state, so please, consult with a qualified attorney in your area for actual legal advice. All right, let's get into it. Rule number 10, the preemptive documentation strike. This is the very first thing you should do, and it could save you from a world of hurt. It's so simple, you can do it with 2 taps on your phone. But 99% of people only think about it after things have already gone sideways. The second you see those flashing lights, or an officer approaching, you need to start a recording. Audio is good, video is better. Then, you create a verbal record. It's not about being confrontational. It's about establishing the facts from the very beginning. Here's a simple script that has kept countless good people out of trouble. It is, date and time. I am at location and am being contacted by law enforcement. For the safety of everyone involved, I am recording this interaction. Why is this so powerful? Because you've just created an objective record. You've established your cooperative mindset and your awareness from the first second. In a he said, she said situation, a time-stamped recording is your best friend. Courts can't ignore what happens in those first crucial moments. And this simple action can mean the difference between a clean record and a crippling legal battle. Rule number 9, the disclosure decision matrix. This is where a lot of gun owners get tripped up. Do you tell the officer you're armed? The answer is, it depends. This isn't a simple yes or no, it's a tactical decision. First, know your state law. If you're in a duty to inform state, it's not a choice. You have to disclose, and you should do it immediately and calmly. But in other states, you have to read the situation. Let's be clear. Never ever just blurt out, I have a gun. Those 4 words can send an officer's adrenaline through the roof. Instead, you want to de-escalate and control the narrative. If you choose to disclose, here's how you do it. Officer, I want to let you know that I have my concealed carry license, and I am lawfully armed. My firearm is located on my right hip. My hands are going to stay right here on the steering wheel. See what you did there? You established your legal status. You told him where the firearm is so there are no surprises, and you showed him you are not a threat. You've taken control of the most dangerous part of the stop. Rule number 8, the movement narration defense. This tactic has saved more lives during police encounters than just about anything else. It's simple. Announce every single move you make before you make it. Officers are trained to react to threats, and to them, sudden, unexplained movement from an armed person is a major threat. So, you have to be the one to narrate the entire process. Think of yourself as the play-by-play announcer for your own actions. For example, Officer, my wallet is in my back right pocket. I need to reach for it to get my license. Is that okay with you? Wait for them to acknowledge you. Then continue. Okay, I am now slowly reaching for my wallet with my right hand. My left hand is staying visible right here. This isn't about being submissive. It's about building a clear, undeniable record that your actions were deliberate, announced, and non-threatening. I've reviewed dozens of tragic shooting incidents, and the one thing survivors had in common was that they slowed things down and communicated every single move. Rule number 7, the constitutional carry shield. If you live in a constitutional carry state, this one is for you. A lot of folks think it means they can just open carry without a care in the world. That's a dangerous mistake. Here's the reality. Police can still detain you if they have what's called reasonable, articulable suspicion that you're involved in a crime. But, and this is a big but, they cannot detain you simply for the act of legally carrying a firearm. If an officer stops you for legally carrying, here's how you handle it, calmly and professionally. Officer, I am legally carrying this firearm under my state's constitutional carry laws. I am not committing any crime, but I'm happy to cooperate within the bounds of my constitutional rights. The key phrase here is within the bounds. You're not being difficult. You're reminding the officer that there are legal lines. He may try to disarm you for officer safety, and we'll get to that specific phrase in a minute. Your job is to remain calm and put the burden back on him to justify his actions with facts, not feelings.
Rule number 6. The vehicle fortress defense. Your car is your property, and you have rights inside of it. But during a traffic stop, it can feel like you have none. The first 30 seconds of that stop will determine everything. Here's the protocol. When the officer approaches, have your hands at 10 and 2 on the steering wheel. If it's dark, turn on your interior dome light. When he asks that classic question, do you have any weapons in the vehicle? And you've decided to disclose, this is your answer. Officer, I am licensed to carry, and I am armed. My firearm is secured and poses no threat. I do not consent to any searches of my vehicle or my person. In one sentence, you've been honest, you've reassured him, and you have clearly and politely asserted your Fourth Amendment rights. Remember, the right to refuse a search isn't being difficult. It's your constitutional right. Don't let anyone make you feel guilty for using it. Rule number 5. The home sanctuary protocol. When police knock on your door, your instinct might be to be polite and open it. That can be a huge mistake. The Supreme Court has repeatedly affirmed that your home has the highest level of Fourth Amendment protection. Unless they have a warrant, you are under no obligation to let them in. The biggest mistake people make is opening the door wide, which police can later claim was implied consent to enter. Instead, speak to them through the closed door. If you must open it, step outside yourself and close the door behind you. Here's a script to protect your sanctuary. Officers, I'm happy to talk with you, but I do not consent to a search or to you entering my home without a warrant. We can speak out here on the porch. It's polite, it's firm, and it's legally sound. You are not obstructing justice. You are exercising a right that countless Americans have fought and died for. Rule number 4. The escalation recognition system. Every cop knows that encounters can go from routine to dangerous in a split second. You need to know it too. Recognizing an officer's pre-attack indicators or signs of escalation gives you time to react and de-escalate. Watch for these warning signs. Their tone shifts from conversational to commanding. They start ignoring your questions or your stated rights. Their body language gets aggressive, blading their stance, placing a hand on their weapon. They start treating your legal gun as automatic proof of criminal intent. When you see these signs, you shift into a mode of defensive compliance. You slow down your movements even more. Your answers become shorter and more direct. And you might say this to de-escalate. Officer, I want to make sure we both stay safe. I am not resisting, and I will comply with all of your lawful orders. That little phrase, lawful orders, is important. It subtly reminds the officer that you know your rights and that their authority has legal limits. Rule number 3. The Miranda activation trigger. Most people think Miranda rights only kick in after you're arrested. That's a deadly myth. By the time you're in cuffs, you may have already talked yourself into a felony. The moment an encounter shifts from a casual conversation to an interrogation, what the law calls a custodial interrogation, you need to invoke your rights. How do you know it's shifted? The officer starts asking accusatory questions. They physically block you from leaving. They tell you that you are not free to go. At that moment, you say one thing and one thing only. Officer, I am going to remain silent. I want a lawyer. And here's the hardest part. After you say it, you must actually remain silent. Don't try to explain yourself. Don't answer, just one more question. Silence is your absolute best defense until your attorney is sitting next to you.
Rule number 2, the Silent Shield Protocol. This is the all-in-one tool. It combines your most critical constitutional protections into one powerful statement. I've had attorneys tell me this single phrase is the most effective tool a citizen has to stop an unconstitutional encounter in its tracks. When an officer is violating your rights, pressuring you, searching without consent, or interrogating you after you've said you want to leave, you deploy this. Officer, I am invoking my Fifth Amendment right to remain silent and my Sixth Amendment right to an attorney. I do not consent to any searches. This is not a magic wand, but it is a legal firewall. Once you have clearly invoked these rights, any evidence or confession they gather after that point can be thrown out of court. It draws a clear, bright line that tells the officer, and later a judge, that you know your rights and you are formally exercising them.
Rule number 1, the Officer Safety Destruction Protocol. And here it is. The number one concept you need to understand. For 50 years, the two words officer safety have been used as a blank check to justify almost anything. Disarming citizens, illegal searches, you name it. It was the go-to excuse. But the courts, especially since the landmark Terry versus Ohio case, have been clear. An officer's safety concerns must be based on specific and articulable facts. It can't just be a vague feeling or a general policy. They have to point to something you did that made them believe you were a specific threat. So, when an officer tries to disarm you or search your car for officer safety, you have the right to ask for that justification. Here's how you do it, respectfully but firmly. Officer, I understand your concern for safety, but can you please articulate the specific reason you believe I pose a threat? I am a law-abiding citizen exercising my constitutional rights. This puts the legal burden right back where it belongs, on them. You're asking them to justify their actions based on the legal standard required by the courts. If they can't articulate a specific reason, your specific actions, your specific words, your specific behavior, then their actions may be deemed unconstitutional. This single principle is the ultimate shield for a law-abiding gun owner. Look, these 10 rules aren't just legal theory. They are practical tools. Knowing them could be the difference between getting home safely to your family and becoming another tragic headline. If this information was valuable to you, then hitting that subscribe button and sharing this video with every gun owner you know isn't just a nice thing to do. It's our duty to help our community stay safe, legal, and free. Stay smart and stay safe.